Will you be going forward without a lawyer, or are you asking time to hire a lawyer?
So due to recent events of late, I would very much like the opportunity to attempt to hire a lawyer.
Ms. Escoto?
That's fine, Judge. This is just a petition to enter a QDRO.
Remind the court, because this is a new filing, Mrs. Scotto, in the original final decree of divorce was a division of retirement ordered in the final decree?
It has been, Judge, and I uploaded into Caseline because I did send Mr. Trad the proposed QDRO. He had a change. I made that change. There was another change requested, but I'm not going to remove that particular provision because of what the decree says. But both the original petition to enter the QDRO with the Exhibit A, which is the divorce decree, and the proposed QDRO have been submitted into Caseline, and the QDRO has been also filed. The proposed QDRO has been filed with the district.
So I just wanted to confirm. So what Ms. Galeano here is requesting is just an entry of an order that conforms to something already granted by the court in the final decree of divorce?
Correct, Judge.
All right. So now the question then to you, Mr. Trad, is knowing, and I'm going to assume for the sake of argument that everything that Mrs. Cotto has told the court is true and accurate. Knowing that the court has already ordered this to happen, how much time do you believe would be reasonable and necessary to look for a lawyer and hire a lawyer?
So
into the microphone.
So due to, I agree completely, the final divorce decree has been signed, and there are very concrete limitations as to the awards, which is what is being contested at this point. At least on my end, I went ahead and tried to contact a lawyer, and the earliest date that they could see me, even schedule an initial consultation, would be May 11th. So I'm asking for whatever time the court sees fit to allow me to be able to hire a lawyer at this for this.
So let me tell you what the court is thinking, so that you know how best to respond. If Mrs. Cotto had said, this is a new petition because I'm asking for something that wasn't ordered, that means some lawyer, whoever you hire, is going to have to do a lot of research and homework and background for this case. Having heard that she's asking for, she's asking for, on behalf of her client, for something that was already ordered, all the court needs to do is, was it ordered and what needs to happen? And there you go. The amount of work, ostensibly without knowing anything else, that a person needs to do to get up to speed and to present your case and defend your position, whatever it is not this much, but it's much less. So I think a month is not reasonable, but that's why I'm asking you how much time, so that I know. I mean, frankly, I think a week or two is more than sufficient. However, if you have other considerations, financial, time limitations, medical situations, those are the things that I need to hear, because to the court, this, because it's already ordered, is much more cut and dry than other situations. Knowing that that's what the court is thinking, how much time do you reasonably need, Mr. Trad?
If I get the full 30 days, that would work really well. I agree completely, Your Honor, that the final decree is already ordered. It's already set in stone. Where there's some verbiage in this new quadrant, in this new addendum, that would substantially change the award amount, and that is the part that I would need legal counsel on.
So
it would change. I didn't follow, and I apologize to you, Mr. Trad, but it would change what now, if granted?
So the whole point is there is a finite amount awarded in the final divorce decree, which was agreed upon and which was what's called mediated and sent over to my lawyer. So I agree completely with the court, Your Honor. There should not be very much here. However, there was a verbiage entered in the addendum that would substantially change that award amount, that final award amount, and that is the part that I'm seeking legal counsel over.
All right. Knowing all of these, having heard that response, how much time you believe would be reasonable and necessary, Mrs. Cotto?
Judge, 2 weeks. It shouldn't take as long as that. I'm actually doing this for free for Miss Galliano. For whatever reason, the quadro was never entered. We did the decree, we did the special warranty deed, and for whatever reason, the quadro wasn't entered. The parties were divorced, judged by this court in 2022. And so this is just a matter of formality. He just does not like one word in there, but I can't give him legal advice. He needs to have an attorney read the whole paragraph so that he understands why that one word is in there.
Ironically, so I'm looking at the court's calendar. Request is 2 weeks, 4 weeks, and we have a setting on May the 5th. So it's not 2, it's not 4. We have 3. So there it is, May the 5th at 2 p.m. Anything else on this case, Mrs. Cotto?
The court should know that there is a modification that has been filed by Mr. Trad set for May 5th. So I'm hopeful that his attorney, Juan Garcia, can also take care of this, as I will be representing Ms. Galliano on that case.
Is that 2021 FLA 10363?
That is 2020, I'll tell you right now. 2021 FLA 1036 C3.
Do you have a companion case? This is perfect. I wish I would have known that, because that is the best and most ideal situation and setting. All right, Ms. Galeano, do you have any questions for the court?
No, Your Honor.
Mr. Trad, do you have any questions?
I just want to clarify, so that the final date that I have to be able to consult with.
Closer to the mic, please.
Into the microphone?
So I just want to ensure that I understood the time that I do have to be able to confer with the legal counsel for this is on May 5th as well.
No, sir. Your final deadline is probably tomorrow. I mean, so that means your setting is on May the 5th, which means you need to look for a lawyer, talk to a lawyer, and hire a lawyer well before that date. That doesn't mean go out and find someone on the 5th. That means be ready to have your case heard on the 5th. But what Mrs. Cotto just told the court, and I have what my notes say is that there's a companion case, and
I did reach out to
the notes. My notes are in there. Thank you, Miss Flores. Your companion case is already set on May the 5th. So on that date, you're going to come in for 2 final hearings. First, on the motion to modify, and now also on this quadro, which quite frankly should work best for all, because you're going to come into court on one day and not one day on one day on the other. So all that to say, don't wait until the 4th or even the week before, but try to get someone as soon as possible.
Understood, Your Honor.
All right.
And just so the court knows, Judge, I did my due diligence. I reached out to his prior attorney in the divorce just to avoid all of this. And that person told me that he was not representing Mr. Trad. That's why the petition had to be filed.
Yeah, and the other thing you should know, to put you at ease, Mr. Trad, so you really need to hire a lawyer as soon as possible, but you don't have to. The court really, it's going to be almost, I mean, unless you all throw a wrench into, I mean, I haven't seen it, but the court is going to look at the black and white letter of the divorce decree and then just figure out what was ordered and then effectuate its own orders, unless you all come up with some novel.
If that's the case, and I'm sorry, if that's the case, if you feel that I do not, because it is going to be based off of black and white, then I believe we can proceed with my concerns on that one word, as Mrs. Foto Lopez mentioned.
Knowing all of this, you're telling the court that you want to go forward today?
If the court, based off of what you just mentioned right now, Your Honor, if you will be just if it's going to be on black and white, and there's really no difference if I have an attorney or not, I do have a very big question on that one word, as Ms. Lopez Foto mentioned. But if there's no real big difference, if I have legal representation on that or not, if it's going to go solely based on the divorce decree, then I feel that we could move forward.
To fully answer your question, I'm not saying that it's going to make a big difference or it isn't. What I'm saying is, as a matter of law, you're gonna be treated the same way with a lawyer, without a lawyer, and the question posed to the court is gonna be answered the same way whether you have a lawyer or not. Now, the only difference is whether you're gonna have legal advice or not. If you're comfortable going forward, it's your decision. It's your request to look for a lawyer and hire a lawyer, but you don't have to. I would surmise, without knowing anything else, that you're going to get the same decision in any event, because the decree is going to say one thing and the result is going to produce whatever is in conformity with that decree. Unless you all come up with some interesting scenario that I just haven't seen, but it's up to you. It's your request for more time.
Your Honor, I'm sorry, if it's black and white and the standing will rely on what's stated on the divorce decree, then I'm fine with moving forward.
His request to withdraw the request to continue. Are you ready to go forward, Mrs. Cotto?
Yes, Judge, and this is really just argument. I'd ask the court to take judicial notice of the pleadings before the court. Ms. Galliano filed an original petition to enter the post-divorce qualified domestic relations order on March 17th of 2026. Mr. Trad was in fact served, and he is here making a general appearance. The court filed, actually signed a agreed final divorce decree that has been uploaded to Caseline. And the court signed the same on February the 16th of 2022. I'll ask your staff, Judge, to refer to the Exhibit A, which is the agreed final divorce decree.
You're asking court staff to prompt?
Yes, Judge.
Court staff will do so.
Judge, and I would ask them to prompt page 38 and 39. So Judge, these were were on the page where the items that were awarded to Miss Trad then, now Miss Galliano. And on R6, if we can go down a bit further, the court will read a portion of the sums, whether matured or unmatured, accrued or unaccrued, vested or otherwise, together with all increases thereof, the proceeds therefrom, any of the following retirement plans, and then it says as follows. Then on the next page, and the operating word there is increases, Judge. 25,000 of husband's retirement plan in the thrift savings plan through his employment. If the court then now refers to the A66 through 873, which is the actual proposed order signed by Ms. Galliano and I. Okay. On page, starting on the bottom of page 2. There you go. This order assigns to the payee an amount equal to 25,000 of the participants vested. And if we can change the page to the next one. Account balance under the plan as of the liquidation date. The account balance under the plan will include earnings. And obviously there's additional standard language about loans and forms of payments and commencements and death procedures. And Ms. Galliano's position is that because the final divorce decree contemplated any increases of the 25,000, that should be awarded to her in the retirement order, and that's how it was prepared. I cannot give Mr. Trad legal advice. I explained to him in my email to him why it had the increase language in there, which is the the earnings, and he refused to sign. But again, the final divorce decree contemplated and any increases of, which are the earnings. But again, I can't give him legal advice. That's why I suggested that he hire an attorney, because I'm not here to explain the language to him. And so Ms. Galeano's request, Judge, that the court sign the proposed order as is, and if the court wishes to not give her those increases or earnings as the decree states, then that's to the discretion of this court.
So let me see if I understand this correctly, Mrs. Cota. Let me ask this question, and then I'll get a response from you, Mr. Trad. If the court understands the considerations in this matter, so the court signed a final decree of divorce in 2022. That's 4 years ago, ostensibly, without knowing anything else. If this was a good investment vehicle for retirement, in 4 years, there have been some increases to that account. Here, what this contemplates is in those 4 years, whatever amount is attributable to the amount that was due to Ms. Galeano should now be given to her. Is that the issue, Mrs. Cotto?
Yes, Judge. So whatever interest, the $25,000, we're not touching anything else from his TSP. It's just the $25,000 and the increases thereof from the $25,000, nothing else.
So here's the question to you, Mr. Trad. So you don't have a dispute that under the terms of the final decree of divorce, Ms. Galeano should get $25,000, correct?
100% agree.
Into the microphone?
100% agree.
So the question before the court is, if this is a good investment vehicle, and I don't know anything about your retirement account, but the way these things work, they're supposed to increase in value through interest and good investments over time. If you have one of these really good accounts, there have been increases from the date of the final decree of divorce till right now. In 4 years, there's been some interest where it's $1 or 100,000, whatever that amount is. The question before the court, as posed by Mrs. Cotto, is, should Ms. Gallardo get the benefit of the interest attributable to her $25,000, yes or no? What do you think the answer should be?
So I do not believe she is entitled to that amount. First of all, as you mentioned, your honor, as the court mentioned, this divorce happened 4 years ago. I do not know why this quadrant wasn't entered at any time prior to that, but to utilize my TSP as a de facto investment account, I don't think that's the correct engine. Now, whenever we went through mediation, which was a 3-hour-long mediation, one of the things that was agreed upon was the finite number, which is on page 39, where it specifically sets 25,000 of a husband's retirement plan in the thrift savings plan through his employment. I know Ms. Escoto Lopez mentioned Title R6, but from what I'm understanding, that's more that stanza, that paragraph describes more of the retirement assets. However, what is concrete in this divorce decree was the 25,000. It did, if there was to be, and that's what was agreed upon during the mediation. Now, under subsection A or A under 36, I'm sorry, R6, which is page 39, 25,000 of the husband's retirement plan in the thrift savings plan through his employment had the contemplation been that she would have she was entitled to earnings, then I believe that should have been entered in that section. But when the party's property was distributed equally, that 25,000 was taken into account as being the part of the deciding factor of distributing the property equally.
So in order for the court to make a good decision, Mr. Trad, let me ask you 3 questions. First question is, I understand your argument why Ms. Galeano shouldn't get the benefit of the increase, if any, and I don't know what it could be or is, but let me ask the question in reverse. Why are you entitled to that amount?
Your Honor, I believe that amount, I don't know why she didn't remove it. My understanding, the only reason that I could have found that she did not remove remove it was because she, for whatever reason, was not gonna roll it over into another investment account to where there would not be penalties,
Objections of
Right,
fact,
right,
not
right. I
indemnity.
can't fix what did or didn't happen, but my question is, I understand completely your argument why she shouldn't. But the question that I have is the reverse. Why are you entitled to that?
so I don't see how her failing to remove the monies at an accurate time now puts the onus on me having to be responsible for those actions.
So then let me talk to you, let me ask you a question on remedies, and what remedy means in legal terms is what should the court do to put you in the same position that you were back then, because that's what you're asking, only 25, because that was what it was ordered back then, and Ms. Galeano, the position she was back then. This is it's a legal term called remedies, but it means what should the court do? If the court puts you back, as you're requesting, into the position you were back in 2022, if I use your logic and your remedy, put us back in 2022, she gets 25 and we're cut. Well, that means by logical extension, she should get all of the increases, not just her portion, because that puts you, everybody, back into the position they were back then. I don't think that would produce a good result.
Understood, Your Honor. So,
You see the flaw with the argument.
so Your Honor, that's my sense of whatever the court finds that is the most logical, fair,
Yeah,
and within the grounds of the law, then that's what I'll fully respect.
I fully believe that the result that would get to the most fair, right, just orders that effectuate the orders. I mean, these were agreed to, right? It's not like the court said, you get 25 and only 25. This was an agreement. But I think that you should be given all of the benefit of everything but the 25 and interest. And Ms. Galeano should get the benefit of her 25 plus interest, because one more time, I don't see any clear position that the law could give you that says, based on something that I don't know, whether it was this lawyer, that lawyer, or something having to do with your plan, it didn't happen. I can't fix that, right? So the question is, are you entitled to the full thing? I think the law, well, no, I don't think, I know the law would say, no, that's not fair, right, and just, because your bank account, your retirement account has had the benefit of the interest attributable to money that really isn't yours under the law. And if the court agrees with you, the problem is that if I put you back into the position you were in 2022, she gets 25,000 plus the interest on everything over the last 4 years. And I don't think that's a good outcome either. I don't think that's a good, right, and just outcome. So, Ms. Escoto, these are the court's findings. Do you have a proposed order with those parameters?
Yes, Judge, it was what was e-filed with the court and what was on case line.
All right.
The only thing I ask if the court is going to sign the same, TSP requires that an addendum be submitted to not disclose parties' social security numbers or dates of births on these orders for identity theft reasons. And so if Mr. Trad can just send me his social security number so that I can plug it into the addendum, that addendum is not filed with the court. It is sent certified mail to TSP with a copy of the order and a copy of the final divorce decree. If he can just email it to me like he has been communicating with me, I would appreciate that.
Any objection to doing that?
None whatsoever, Your Honor.
All right. Let's do this. I have signed it because I have already ruled. I'm going to tender the original to our coordinator to process with the clerk. If you have an objection, Mr. Trad, I will gladly entertain it on May the 5th. I'm not setting it for hearing, but I'll certainly hear it if there is any. But I fully believe, I'm squarely confident that this was the most best, right, and just outcome in this case. Do you have any questions for the court, Mr. Trad?
Thank you for your time.
Any questions for the court, Ms. Galeano?
No, Your Honor.
Any other issues on this case, Ms. Escoto?
No, Judge.
All right, I wish you all the best. We'll see you on May the 5th. Good luck to all.
Thank you.
Thank you, Judge.